Hello and welcome to Innovation Insights webinar series. I am Srinata from Institute of Inspiring Innovation. Thank you for joining us on Innovation Insights webinar series, where we bring thought leaders and subject matter experts to the spotlight for sharing knowledge, experience, models, methodologies, or best practices, essentially for the audience to gain insights and benefits in their respective innovation, entrepreneurship, and entrepreneurship journeys. This session will be facilitated by Harsh Pangi on the topic Basics of Intellectual Properties. Harsh has a diverse professional experience of 17 years working for companies like Infosys Technologies Limited and Tata Elxsi India Private Limited in the field of engineering and technology, with the SAP Labs India Private Limited in the field of intellectual property. He is an innovation coach with Institute of Inspiring Innovation. He is also a mentor and advisor with various startup accelerators and incubation centers across the country. This session will have a 50-minute presentation followed by a question and answer. Feel free to type your questions in the chat box. We will bring them up in the end. Now, I would like to invite Harsh Pangi to take us into this session.
Thank you, Srinata. Thank you for that introduction and the opportunity to speak on the topic of basics of intellectual property. I'm hoping that the participants will learn something new from today's event, and hopefully we will have a series of where I can come and speak on different topics within intellectual property. So without any delay, I would like to begin my presentation. So we begin the session by defining what intellectual property is, right? So creations of mind is referred to as intellectual property, right? So whatever your mind is able to conceive or think or create can be referred to as intellectual property. Now, whatever comes to your mind, right? It can be in the form of ideas, expressions, symbols, names, or designs. Since your mind is able to conceive different types of thoughts, you have different types of intellectual property to protect each type of creation of mind. So since it's an intangible right, when one procures a suitable right, it becomes an intellectual property right. So before we jump into learning about what are the different types of intellectual property, we'll begin our discussion with a nice cup of tea. So have you ever wondered if a cup of tea can have any intellectual property associated with it? And the answer to that is yes. So all the types of intellectual property that you can see on your screen, which include patents, trademarks, design, copyright, geographical indications, and trade secrets. These are all different types of intellectual property that are associated with the cup of tea. So as we go through the presentation, I will connect it back to how it is related and how one can procure a specific right. So we'll begin with the basics. So this is applicable to all the types of intellectual property that we would be learning through the session today. So every type of intellectual property is a territorial or jurisdictional right? So it means that any type of intellectual property is restricted to a specific jurisdiction or territory. So it means that if you procure a right in a specific country, then the right would be restricted to that specific country. And this is applicable to all the types of intellectual property that we would be visiting today in the session. Whoever acts first is able to secure the right, and registration is mandatory for enforcement. every intellectual property comes with a limited validity, and it's referred to as a term. So every type of intellectual property comes with a limited term of monopoly. So when you hold a right, when you hold an intellectual property right, it is nothing but you hold a monopoly for something. And when it comes to the different types of intellectual property, the general processes, you prepare and file an application. There is an examination phase, and then on merits, either the IP would be granted or rejected. So we learned that the mind is able to conceive different types of creations, right? In the basic definition of what intellectual property is. So each type of creation can be protected by different types of intellectual property. So broadly, the different types of intellectual property are patent, trademark, copyright, trade secret, geographical indications, and industrial design. So each type of intellectual property here protects a different type of creation or is associated with a specific type of content that it provides protection to. So we'll begin our discussion with a trade secret, right? So any compilation of information that has an economic value and gives you an edge over your competition is referred to as trade secret, right? So for any piece of information or compilation of information, so there are three criteria. One is the compilation of information should be known to a limited group of people. Second, it should have some economic value associated with it, where you can leverage over your competition. And third, it should be known to a limited number of people. So onus lies on the person to keep that information a secret. So typical examples include R&D information, inventions, designs, method, internal processes, right? Trade secrets can typically be protected through non-disclosure agreements. So in India, it is protected under the contract law, and the validity of a trade secret is perpetual. So connecting the dot back to the cup of tea, the secret kept tea recipe can qualify for trade secret protection. So another classic example of a recipe is the Coca-Cola concentrate, right? The Coca-Cola company has been able to keep the Coke concentrate a secret for several decades now. So the way they have done that is the Coke concentrate comes in sealed containers to bottling plants, where a known amount of concentrate is mixed with aerated water, bottled and then marketed. So in that way, the Coca-Cola company has been successful in keeping the concentrate a trade secret, and no one has been able to reverse engineer it, right? Today. The next type of intellectual property is a geographical indication. So geographical indication indicates a source or origin of a product or a good. It's generally applicable to agriculture, natural or manufactured products, generally associated with handicrafts or industrial goods. So classic examples of geographical indications are SIMT, Swiss watch, Cuban cigars, Mysore silk, Hyderabadi biryani, right? So these are all examples of a geographical indication. The validity of a geographical indication is for 10 years and it's renewable for another 10 years. So in all, you get protection for 20 years from the date of filing the application. So what does geographical indication actually indicate? So it indicates that the product originating from that region has some special attributes, has gone through certain processes, is associated with a quality, and that's the reason it qualifies under the GI. So let's take the example of Swiss watch. So what does Swiss watch indicate? That the parts of the watch have been procured from the Swiss region, it has gone through a manufacturing and assembly process in the Swiss region. It has some regional attributes associated with the quality, which is why it would qualify as a Swiss watch. So connecting back to teas, teas with special flavor and quality are linked to geographical region and can be protected through GIs. So Assam tea is one example. Darjeeling tea is another type of example. English tea is another type of example that would qualify under the GI. So the next type of intellectual property is an industrial design. So industrial design is also referred to as a design patent in some jurisdictions. So industrial design is a type of intellectual property that provides protection to the look and feel aspects of an invention. So if you have a product and the way it looks, right, the non-functional aspects, so whatever is visible to your naked eye, if that design is unique, so the design can include shapes, patterns, arrangement of lines or colors or combinations, right? If that is unique, then it can be protected through industrial design. So a lot of times I get queries saying that I want to protect the design of a system or a design of a solution through an industrial design, or design of a circuit through an industrial design. So this is not possible. It is only restricted to the look and feel aspects. So the way you design, the methodology that you would follow to design a circuit or a system, or the design of the circuit or the system itself cannot be protected under industrial design. So validity is typically 10 years from the date of filing the application and is renewable for another 5 years. So when it comes to a cup of tea, the look and feel of tea products such as cups and packaging can be protected through industrial design rights or design patents. So the next type of intellectual property is a copyright. So copyright protects expression of an idea. So please be mindful about this. We'll be talking about patents as we go through the presentation. Copyright protects expression of an idea, while as patents protect the idea itself. So typically copyrights need not be registered. By default, copyright is created the moment the content is created. Okay? You can protect copyright by using the symbol C with your name and year of creation. Many a times, people may have seen the symbol C with the name and the year and followed by 3 golden words, all rights reserved. I'm pretty sure none of them are aware what those rights are. Even the original copyright holder will not know what those rights are. So copyright owner has the rights to reproduce, translate, adapt, perform, distribute, publicly display the work. So these are the rights that you get by default when you create a copyright. So typical examples of what can be copyrighted: code, website, database design. So any content, right? Digital content, marketing materials, educational content, all of this can be protected through copyright. Registration is not mandatory. However, if you need to enforce your rights, so when I say enforce your rights, let's say somebody copies and you want to sue them, that is when you should have the registration process completed before suing them. So unless you have registered and procured the rights, you will not be able to sue them or enforce your rights. So this is one exception, and one type of intellectual property that does not require a registration. However, if you want to enforce your rights, you will need to register it. Right? So it's not a substitute for any other type of IP. So for example, patent. Right? We studied or we learned about creations of mind in the first slide. So whatever your mind is able to create can be protected through intellectual property right. So each type of content can be protected by a specific type. So you cannot file a patent for a content, and you cannot file a copyright for a technical solution. So I've seen a lot of people doing that. They think that these rights are interchangeable, and uh, either of them, if I have either of them, I can, it's as good as I have the IP with me. It is not so. If you file a copyright for a technical solution, you will get a registration number probably, but you will not be able to enforce it. So that's how it is. So you will have the right, but it will be only on paper, and it is neither enforceable nor licensable. Right? Typical term of the copyright is life of author plus 50 to 100 years. So here I've put a range because depending on the type of content and the jurisdiction or the country in which you register, the number of years varies. So for sure, it is valid till the original author is alive, and it is valid for another 50 to 100 years after the author is no longer alive. So when it comes to the cup of tea, so books about tea automatically receive copyright protection. So just like Orwell's A Nice Cup of Tea, now out of copyright in many countries. So any type of expression can be protected by a copyright. So this is one example of how expressions can be protected. Next type of intellectual property is a trademark. So any name, symbol, or an expression that uniquely identifies a product or a service or your business, right, is referred to as trademark, right? So it can be a word mark, which can be a single word. It can be a word embedded in a specific logo, or a word embedded in a logo with an expression, right? So all these combinations are possible. So registration is mandatory for enforcement, judicial recognition, and validity in courts, or for protection. So this we learned that for copyright it is not mandatory, but for any other type of IP other than trade secret, registration is mandatory for enforcement. Likewise, if you need to enforce your rights, uh, uh, judicial get valid, you need to have a validity in the court or have a judicial recognition, then even copyright registration is mandatory. So once you file an application, you can use the symbol TM, and once it goes through the examination process and gets granted on merit, you can use the symbol R with a circle around. So when it comes to the cup of tea, brands give consumers confidence in what they are buying and allow tea producers to stand out from the competition and fight copycats. So trademark is basically protects your brand. The process in India is you will need to come up with a description of your business or product or service, a very brief description of 2 or 3 lines as to what it is doing, and then based on that we will identify the classes or categories in which you need protection. So there are 45 goods and service classifications that are defined and managed by WIPO, which is the World Intellectual Property. So depending on the nature of your business or your product or your service, your your trademark could qualify in more than one category. So more than one class, there is a possibility that you may have to register in 2 or more classes also. So validity is for 10 years and it's renewable perpetually. So every 10 years, you keep paying the renewal fee and your trademark holds good, is enforceable. So a typical pitfall when it comes to trademark is registration in the wrong class. So if your product or service or business description is not proper, or the person who is filing your application makes a mistake in identifying the right classes, there may be possibility of you registering in the wrong class. In such scenario, you will not be able to get protection. You cannot change the class, you cannot edit the application later on once it's filed. If you want protection in other classes, you will need to refile the application. So next type of intellectual property is a patent. So let's first define what a patent is. Patent is an exclusive right to a technical solution for a problem. So you may have one or more solutions for a problem, and once you procure an exclusive right or monopoly for those technical solutions, you hold the rights for it. And typically the term, it's referred to as the term of the patent is for 20 years from the date of filing. So you can hold the monopoly or exercise your rights for 20 years from the date of filing the application. Again, this is a type of intellectual property which is specific to a jurisdiction. So I would like to revisit the definition of jurisdiction. It is restricted to a specific country. There is no global patent. There is no continent patent. You need to file application in specific countries to seek protection. So there are two international treaties through which you can seek international protection. One is known as the Paris Convention, and second is known as the Patent Cooperation Treaty, or the PCT. So Paris Convention allows you to file the application directly in those respective countries. So you first file in India. So the typical process of filing in India is you file in India, wait for 6 weeks, and before the expiry of 12th month, you need to file the application outside India. So you can either file it through PCT or through Paris Convention. PCT allows you to file in multiple countries using a single application. So they have a system where you can make a single application and choose the countries in which you need protection, pay the respective patent office fees. This is very, very important. Again, there is a confusion in the community or understanding. People think that by filing a PCT application, they are by default protected in the 153 countries of which the PCT, so PCT has 153 member states or countries, and by default, you get protection in those 153 countries. It is not so. You have to select the countries in which you need protection and pay the respective patent office fees. So there are two types of patent applications that you can file. One is known as a provisional and one is known as a complete or the non-provisional. So let's first understand what a provisional patent application is. So provisional patent application is typically filed when you're at ideation stage. Let's say the crux of your invention is ready and you are experimenting with certain additional features or functionalities and need time for it. So you can file a provisional patent. Provisional patent is typically valid for 1 year from the date of filing. It is never published, it is never examined, and it never matures into a granted patent. So one might ask, what is the advantage of filing a provisional patent application? So like I said, it acts like a placeholder. Okay. So once, if you're in ideation phase, you can file a provisional patent and secure a filing date. So I'll explain that with an example. So today is January 27th, 2022. So let's say we filed a provisional patent application today. It would be valid for 1 year. So within 1 year, you need to follow it up or file a complete or a non-provisional patent application. So unless you file the complete or the non-provisional, the process is not complete. So whenever you file in this 1 year period, it would be as good as filing the complete application today itself. So all that provisional patent application is doing is buying us time for a year, and you could use this time to experiment or change some additional features, not the crux of the invention, but some additional features can be changed, some additional functions can be added or removed, right? So that is the advantage that you get. So one has to file a complete or a non-provisional patent application within 12 months if provisional has been filed. If you think your product or idea or solution is ready, you could skip filing the provisional and file directly the complete application. So that option also is available. So when it comes to the cup of tea, tea related inventions such as kettles, filtering solutions, tea production methods can receive patent protection. Right. So continuing our discussion on patent. So broadly, your technical solution or the idea which can be patented should fall into one of these categories: product, process, article of manufacture, composition of matter, or improvements. Product, I think most of you are familiar. I will not give you an example related to product patent. Process, very simple example of shopping, right? You're shopping on an online portal, let's say like Amazon or Flipkart. So what do you typically do? You go to the website or you open the mobile app, you search for the product, and then there is a product listing. You select the product, add it to the cart, and begin the checkout process, right? So you would select a delivery address for delivery and choose a payment method and complete the transaction. So this is nothing but a sequence of steps, right? The sequence of steps can be patented. So if they meet the criteria of patentability, they can be patented. Articles of manufacture, typically examples include saw, hammer, shoe, mouse pad. So these are examples of article of manufacture. Composition of matter, typical examples would include formulations or ingredients, formulation of creams, or food products, beverages, and then when it comes to pharmaceutical products, the composition of the specific product can be protected through patents or improvements of any of these. So in India or any other jurisdiction for that matter of fact, so there are three basic criteria that define or govern whether a idea or a technical solution is patentable or not. First step is the novelty, right? What is new about the technical solution, right? Second is the inventive step. So this is the most important criteria. So it's referred to as inventive step in India. It's referred to as a technical effect in Europe. It's referred to as non-obviousness in the US. So inventive step is nothing but how much technically advanced your solution is from what is existing out there. So this has a significant amount of weight when it comes to patentability. Third is the utility. So again, I get a lot of queries saying that I have invented something which has a new utility, right? So let me give you an example of new utility, right? Very, very simple example. So consider you have invented a screwdriver, right? So what is the primary utility of the screwdriver? It is used to turn a screw, right? You screw or unscrew using a screwdriver. Now, if you say that I'm going to use the screwdriver to open a lid or open a box or stir your coffee, that becomes a new use or new utility. New utility cannot be patented, right? You're using the same product, or the product may be present in specific area or may not be present in specific area. And when I say product, it is the technical solution, not the product per se, but the technical solution. So if the technical solution is not present in a specific area, and it does not have a inventive step, right? There is no technical effect or technical advancement, or does not have an inventive step. Just by having a new utility, you cannot get the patent granted, right? So some of the things that cannot be patented, that is defined by the patent offices: processes of treating humans and animals, abstract ideas, so rules. So let's say there is a transaction or a game or a way of doing, let's say, way of doing a transaction or a business between two people. Again, it comes under business method, right? So these are not patentable, right? Because they would constitute as abstract ideas. Likewise, specifically, business methods are not patentable. So one may ask, can you give us an example of a business method? So if you are, let's say, selling a product on a platform like Amazon or Flipkart, and you have built a platform or a framework to sell services, right? That is a new way of doing a business. It is nothing. So all that you're doing is providing services through your platform. So that is not patentable, right? So some of the myths: treating IP as a commodity. So please watch $1 Billion Code on Netflix. This is a must watch for all businesses, especially technology centric businesses, to understand what intellectual property is, what is the value of it, how it is evaluated, what happens when you don't do it right the first time, what are the consequences. So everything is covered in just the 4 episodes, right? The 4 episodes that are there covers most of the aspects related to the intellectual property. So it is a real eye opener to many startups, and one will not appreciate the value of IP till they understand how the process actually works and how one can actually leverage through intellectual property, right? Second myth is cost is restricted to filing the IP only, right? So this is again not true. So we learned in the basics of intellectual property, every IP goes through a process. There is filing, there is examination, there is grant or reject. So there is cost incurred at every stage, right? So before you file a search has to be done, be it patent or trademark or in any other type of IP. Search is generally recommended. Once you have the search, based on the outcome of the search, you can decide whether you want to proceed with filing the IP or not. So there'll be cost incurred at the time of preparing and filing the IP, and there'll be costs incurred at the time of examination phase. So the patent office will come back with a search and examination report, and one needs to respond to that. So there will be a cost involved at that stage. And let's say on merit, your IP gets granted, there will be a maintenance fee that one needs to pay. So there'll be cost incurred at every stage. So please be mindful about this and don't be under the assumption that cost is once you file the IP, it is done, right? I no longer have to bother, or there'll be no other costs. Some professionals may tell you this upfront, some may not. So it depends on the way of their business model, the way they do it. So, but generally, this is how the process works. So there will be a cost at every stage that will be incurred, and one should plan and properly budget for it. So rely on blogs and unsolicited sources of information. So this is again, I have seen a lot of people, they just Google, read up stuff from some website, some blog, and come and start asking questions, or they believe that whatever is written there is the right moment of truth or ground truth, and they start believing that information. So please do not do that. So unless it comes from a reliable source, and when I say a reliable source, someone like a authority like a WIPO, which is, or someone who runs a proper IP firm, right, provides proper IP services, professional services, you can trust such information sources, right? But it's always good to be diligent and validate whatever you have read, right? Don't just rely on one source of information. So one type of IP substitute for other. We briefly touched upon this while we were talking about copyright. So please be mindful. Just for cost purpose, the copyright process is cheaper, the fees is less. So I'll file a copyright instead of a patent. You can file, no one will stop you from filing, but you will get a protection or a right that is only on paper, and you will not be able to enforce your rights. So please first is identifying what kind of protection you need, and then following it up with filing that proper IP. So this is these are two very important aspects. So last one, I can wait. So again, very common notion or understanding in startups for various reasons. Funding not available, not ready, not sure whether they want to pursue with the idea, many reasons, right? So waiting is not going to help. We learned that whoever acts first will be able to secure the right? And the right time to protect your IP is now. So the delay is proportional to probability of losing your IP. So protect your IP before making pitches and presentations to investors or prospective customers. So just give you an example about the wait period. So I'll throw some statistics in. Last year, there were some 50,000 applications that were filed with the Indian Patent Office, right? Of which 35,000 were filed by people outside. And when I say people outside, these are non-residents, maybe Indians, not Indians, or maybe foreign companies or independent foreign inventors from other countries. 35,000 applications were filed by them, and only 15,000 resident applications were filed. The same year, there were 1.5 million applications filed in the Chinese Patent Office. Okay. So this is an example of waiting, right? People want to wait for the right time, for the right moment, thinking that nobody else is inventing, nobody else is innovating, no one in the world is thinking the way I am thinking, right? It is not true. So you can imagine there were like 100 times more applications filed with the Chinese Patent Office. Likewise, there are other jurisdictions where filing patents or IP is not, people don't wait, right? Japan is one such example. UK is another such example. Germany is one such example. US is another example. So you need to plan, budget, and quickly act. Right? Why to protect IP? It gives you edge over competition, prevent copying, access to new markets, and gain value through licensing. So this is very important. First is you need to identify the areas or the jurisdictions in which you need protection. And once you file, and let's say the IP gets granted on merit, you can leverage licensing and making some money through the royalty. So opportunity for collaborations, business, research, innovation, and outsourcing. So this is very well known, well established, be it academic institutes or startups, funding opportunities or collaborations. Business valuation goes up when you have proper IP, a portfolio that you plan and build. Right? Ensure FTO. FTO is nothing but freedom to operate. So if you are a product company, let's say in emerging technology, like let's say medical devices, if you are building a product and going to release in the market, you need to ensure that you do a freedom to operate search or investigation, just to understand what landscape you would be entering into and if there is any possibility of prospective infringement. So this will give you an idea of the landscape, of the type of patent holders and the primary companies which hold patents. And if there is a scenario or a case that you may prospectively infringe, you could consider licensing from that company before you actually launch the product, so that you don't end into a lawsuit or litigation after you have released the product. Strong brand identity and commercial value. This is one more reason why you need to protect your IP. So coming to the do's, best practice is to seek protection as soon as possible. Try to have non-disclosure agreements in place. I know that a lot of investors are not comfortable signing NDAs. It's to be done in good faith. If you're going to pitch to prospective customer, if you want to pitch your solution or a product to your customer, I would suggest please do it under NDAs because it can offer you extended protection. Seek value, try to seek professional help, identify your IP assets before it's too late. So I've had a lot of cases that I worked on in the last couple of years, mainly around the startup community, where there were a couple of them were related to patent infringement. A couple of them were related to trademark infringement. So you need to, identify your IP assets and protect them. So have a strategy to build a portfolio. So this is very, very important. To give you a very simple example, small or large companies who really care or have a strategy are able to build an IP portfolio on a timely basis. So if you want to capture the market or stand out as a technology leader in a specific space, you will need to engage with an attorney or an IP professional very early on in your technology or startup journey and try to build this portfolio with time. Some of the don'ts, please don't false claim without filing any IP. So I've seen a few instances where startups were trying to pitch or are trying to pitch, it's an ongoing thing, for funding opportunities or to get some branding and advertisement saying that we have filed so many patents and the patents have been granted and all. And when I went and looked up, there was no such information available, be it with respect to that person as an inventor or an applicant or the company applying as such. So please don't do that, because there is fine and or imprisonment that you can attract if it comes to the attention of the patent office that such false claiming is being done. So they can legally enforce their rights on you, because these things are defined in the act, right? They can just pick those sections and rules and enforce them, and you may end up in trouble. So don't Google. Google doesn't have all the answers. So try to seek professional help, rely on credible information sources and professionals. Don't do it yourself. So I know Jugaad, this is the Indian way of doing things, but then it doesn't apply to patent applications, especially in the field of IP, not only specific to patents, but especially in the field of IP, because IP is governed by the rules and sections and laws that are already defined, right? So unless you have studied them, you know how to apply them. Just by copying a patent application, you cannot write a patent application, right? patent application is not about structure and template, right? Or formatting, right? Many people will think so by having those jargons which are there in the patent application and putting or writing the way you want, like a journal or a blog article, and filing the application, you're done, right? As long as the patent jargon is there, you are good to go. It doesn't work that way. So there are specific sections defined, specific rules that are defined that govern specific parts of your patent application, be it your title, be it your abstract, be it your detailed description, your drawings. All these are governed by sections and rules and laws. So just to give you an example, Indian Patent Act has about 160 sections and 140 rules. So whenever you file an application, your application would be examined against a subset of these rules and sections. Likewise, US has 379 laws and 1071 rules, right? So unless you know how to apply them and write an application, please don't do it yourself. Please don't try doing it yourself. Don't publish, especially in journals and blogs, or publicly disclose. This is very, very important because once you publicly disclose, some countries have a bar date. So for example, US allows a bar date of about 1 year. So within 1 year of your public disclosure, you are still allowed to file a patent application, but this is not true with India. So it's an absolute novelty requirement when it comes to India. If you disclose anything publicly and it is accessible, right? That piece of information or that product is publicly accessible, electronically accessible, or somehow it is accessible, then you will be denied of a patent application. So with that, I would like to conclude my presentation and open up the floor for questions. Thank you.
Hi Harsh, there is a question from one Mr. Prem in the chat box.
Right.
Okay, will a digital document with the copyright owner's names and year suffice or as proof of copyright ownership? Or do we need a physical printed document mailed and kept unopened?
Yeah, see, as long as you can do that, you can mail yourself the document and keep it unopened. That is one of the options. Or you can just hold a lab book or just copy digital proof of your rights, but you will not be able to enforce it. So if you need to enforce it, you will need to register it with the Copyright Office. Only when you have the rights granted, you will be able to enforce it. But just for protection's sake, for the records, for namesake, you can do that. How intellectual property can be protected in research. So this is again a very, very subjective question. It depends on the area of research, the kind of research you're doing, at what stage you are you collaborating with others or doing it independently? What are your sources of information? How you're collaborating? Do you have a joint development agreement with a institute or the company or the professional with whom you're doing a research? So there are many things that should be considered. So you can probably get in touch with me and we can have like a detailed discussion on that. Is provisional filing enough before publication? Yes, provisional is sufficient before publication, but if you need protection subsequently, if you really need to ensure or get your rights, it has to be followed up with a complete application in India or a non-provisional patent application in any other jurisdiction. So you can take priority to the provisional and file the complete or the non-provisional patent application.
Hi Harsh, thank you so much for the wonderful session. I have a question.
Sure.
Is there an example that where the IP protection here has gotten that value in terms of monetization, even though I did not go and develop something out of it, directly monetized it, but how do I monetize IP?
A very good question, Naveen, and thank you for asking that. So I don't have any specific example that is where such a case exists in India, but in the US, yes. So I'll briefly talk about one technology that is currently being commercialized. So this goes back in 2014-15. So there were a few PhD students who were working on a network protocol, right? Network data protocol. They were studying in Caltech, California Institute of Technology, Pasadena. So they filed a patent out of the research that they did and the solutions that they found, right? Without knowing that in future, whatever they have built or solved, the problem that they have solved, the solutions that they have created would become a part of the commercial product. So subsequently, what happened? Their data protocol was so good that it became a standard. So Wi-Fi 6 standard now has incorporated the solution or protocol that they devised. So subsequently, this was again in 16-17. So Broadcom and Apple started manufacturing hardware devices which were Wi-Fi 6 compatible, and they were not aware of this development, right? Although they never commercialized it, they only got protection. They filed the IP and got the patent granted. They kept the patent to themselves only till Broadcom and Apple started manufacturing hardware chips, which were Wi-Fi 6 compliant. That is when they went and, so Caltech approached Broadcom and Apple and requested them to license it. And these companies did not agree. So they decided to litigate. So they went into litigation and last year it was settled. So combined Broadcom and Apple together, Caltech received a settlement of $1.1 billion. So this is how they could actually leverage through whatever they developed and protected.
Another question is in the companies, right? You worked in corporates and you understood the best human resource.
Right.
Best resource we have is human resource who could think and create intellectual properties.
Right.
So how do corporates encourage people to create this intellectual properties within their organization? Are there any incentives or techniques to motivate them?
Yeah, incentives are there. So a lot of MNCs, including SAP that I was working with, they do have an incentive program. So typically it would be again based in which technology the IP was created, the country from where it originated. So there were many factors taken into account, but there were remuneration programs. So let's say you filed an idea that got scrutinized and shortlisted for filing a patent application. There would be a remuneration paid at that stage. And once the patent application gets filed, there would be another small amount of remuneration that would be paid at the second stage. And if the IP gets granted and the inventor is still with the company, because typically IPs take 3 to 5 years to get granted, right? So if the inventor was still with the company, they would be entitled to get a third remuneration. So a lot of companies have this kind of structure and arrangement where they do reward their employees, and these are considered in your final yearly appraisals as well. So how many IPs you filed, what type of IPs you filed, and what is the quality of the IP. So yeah, there are many things that are taken into consideration, and it can leverage for you in the long run.
Oh, fantastic. So another question, where we say that human resources are the best asset, but I understand that in financial terms they fall into the expense side and liability, unless they're really creating some intellectual property, right? Then they become human capital, and with the capacity to create intellectual capital, then they become and fall under the section of intangible assets. How important is the intangible assets and how valuable is it?
Again, a good question, Naveen. But see, whatever IP gets created, right, you never know how it can leverage for you. So if we go by the 80-20 principle, generally it's the 20% who are the drivers, right? Who drive the, let's say, a mission or an organization or a product. It's generally the 20%. So is the case applicable to IP as well. So if you are able to produce something that can make millions or billions through licensing fee, that will take care of your entire employee base. So I think IBM is a classic example for that. Last few years, I think they have been able to pay all their employees across the world only through licensing fees. So apart from services, apart from the business, whatever revenue, the IP that they have created, they're able to license and have been able to pay the employee salaries and all different kind of remunerations to the employees through the money that is generated through licensing.
Oh, fantastic. That's a great example and great way of sustaining operations, right? Getting IP to work. So intangible asset. How important is the IP in terms of, for a startup, in terms of its valuations?
It again depends on case-to-case basis. Depends on the technology area and the kind of market traction they've had over a period of time. So multiple factors, but yes, IP does play a very important role. I do get requests from investors to do some kind of diligence when they want to invest or let's say look for M&A opportunities. So of late, I've been approached by a lot of investors where they want to know whether whatever IP has been filed, whether it is viable, whether it is valid, does it meet certain quality standards or not? Because like I said, a lot of startups have been claiming that they have filed worldwide IP, but then when you research, when you do a due diligence, you find out that they have not filed anywhere except in India. So there have been different instances, different scenarios. So on a case-to-case basis, it typically depends and varies.
Thank you very much, Harsh, for this wonderful session and sharing the thoughts and innovation insights, right? A lot of insights. Thank you so much.
Correct. Thanks. Thanks, Naveen.
Yeah, Harsh, I wanted to ask you, for copywriting, can it be done at the manuscript stage or only after publication of the, after publication?
Preferably after publication. Manuscript again changes, right? Keeps on changing. Yeah, anything that you change. So once you register or you apply for a copyright, even if you change a full stop or a comma or even a couple of words here and there, or maybe a sentence also, your original copyright will no longer hold good. So generally recommended to file your the final version of your script.
Okay. And how long does a copyright take to be given for a publication?
No idea. Timelines cannot, because post-COVID, everything has gone like out of the window with respect to timelines, because the patent office was closed for a few months, and then there is a lot of IP that has been filed in the last couple of years. So there's a lot of queue. Typically, 1.5 years is what you can expect, but it may be more also.
Okay. Thanks, Harsh. That's very useful.
Yeah.
Thank you everyone for joining Innovation Insights webinar series. I hope it would have helped you to draw some inspiration and insights. Visit www.triplei.today or write us on info@triplei.today for any information you may need. Take care and best wishes to you in your innovation journey.